A very good morning to our lecturer, Madam Bella. So myself is Sahanah Kumar and my partner is Afiq bin Salim. So the topic that we got is about the company constitution, and we will be presenting about the memorandum of association and articles of association. So firstly is about the Memorandum of Association, which is a legal document preparing the formation and registration process of a limited liability company to define its relationship with shareholders. And the MoA is accessible to the public and describe the company's name, physical address, names of shareholders, and the distribution of shares. So for the content of MoA under section 18 clause 1A, the basic requirement needed is the name of the company and objects of the company. So for the company limited by shares, the liability of the members is unlimited. For company limited by guarantee, the liability of the members is limited and that each member undertakes to contribute the asset of the company. And for the unlimited company, the company proposes to be registered and the division thereof into shares of a fixed amount. So the need to lodge MoA, the requirement to lodge the MoA is sent to the registrar and the registrar issued the certificate of incorporation, and then the company acquires legal status of body corporate. So next is the constructive notices to MoA, where a person dealing with a company is deemed to have read the registered document and considered to have understood them. So an example of constructive notice is like the legal advertisement in newspapers, such as the bankruptcy advertisement. So the members have right to have the copy of MoA, where subject need to make a payment of 5 ringgit or such lesser, and a copy of the MoA must be issued by the company after the date of alteration. So the conflict between MoA and AoA is where the MoA can override and overrule any provisions of the AoA which may be at variance with it. So for the alteration of MoA that can be made is the name of the business, convention unlimited to limited, convention private to public, convention of public to private, object clause, share capital, and alteration by the High Court under section 181. So for the construction of MoA under section 33 clause 1, nothing in the MoA must contradict the provisions of the Act unless a contrary intention is provided by the Act itself. A statutory contract binding between the company and its core members and between the members inter se. For the object clause, the legal personality of a company for purposes stated in the MoA, such as the type of activities or business, validly do in its capacity only such things as are within its object and things reasonably incidental thereto and are not prohibited by the law. So for the legality of object, there are 5 unlawful object. Firstly is the forbidden by any law, where the object of a contract is prohibited by law, then not lawful object anymore, then the contract cannot be valid. And secondly is about defeat any law, where any law that court finds the intention of parties to the agreement is to defeat the provisions of law, so the courts can rule the contract as void. And and thirdly is about the fraudulent, where the fraud is made with intention and it is void by nature. Fraudulent objects are void by nature basically. And for the immortal, where someone is forced to do immortal things. And lastly is the object that opposed to public policy, where certain contracts in the name of public policy are restricted and public policy is used in a limited scope for the purpose of lawful object. So next is the lodgement of special resolution, where a copy of the special resolution altering the object and lodged to registrar after 21 days of passing the special resolution. And the effect of alteration is where it takes effect upon lodgement of the special resolution and not upon the passing of the special resolution. And then the altered object shall only be implemented by the company on or after the effective date and not immediately upon the passing of the special resolution. And next is the doctrine of ultra vires, where it is beyond the power and lack of power, which the acts which are beyond the capacity, acts carried out in excess or abuse of the powers of the company by its agent, and acts in violation or in excess of AoA. So the example of case that related to ultra vires is the Ashbury Railway Carriage and Iron Company Wirich, where a company contracted to build a railway line, and the object of the company permitted it to manufacture train stock and parts for railway, not to construct railway lines themselves. And the court held that the contract was void, and the director of Ashbury were entitled to repudiate the contract. So the effect of ultra-virus based on the English law is any transaction which is made outside object class would be void, and based on the Malaysian law under section 20 clause 1, any transaction which is made outside the object class is still valid as long as the party to the contract is concerned about it. And lastly, about under the section 20 clause 2A, the member of the company have right to take action against the company to restrain the performance of ultra-virus act. Under section 20 clause 2B, the company or member of the company can take action against the officers of the company who authorize the ultra-virus transaction. And under section 20 clause 3, the member can claim for the damages. Minister change with the responsibility for the company's petition to wind up the company which entered into ultra-virus transaction. So next is about article of association, which will be presented by my partner Afiq. Thank you.
Hi, Assalamualaikum. I'm Afiq. I will present about the article of association. The definition of article of association, a document that specifies the regulation for a company's operation and define the company's purpose. That means the objective of the companies they put in the article of association. The document lays out how tasks are to be accomplished within the organization, including the process for appointing director and the handling of financial record. This means the way or process they want to select their directors and how they are managed about their financial record also have in the article of association. The nature of article of association, their nature is internal regulation. That means the procedure to be followed for the administrative operation and organization in the company. They must be lawful, or other words, the company must follow the rule or law, and the AoA cannot override and overrule any provision in MoA. The document of AoA is the public documents and open for inspection for the public user. AoA not to be rectified by the court because court has no jurisdiction to rectify, neither correct or amend. Alteration followed by a section 31, statutory procedure of special resolution requires large majority vote. And that's mean if the company want to make the alter of their AoA, they must get the majority from their members in the company. This is the content that have in article of association, like table A, cluster of share, and directors. This I will explain in the other slide. Okay, the first director, their name must be in the MoA and AoA. First secretary also same like a first director. The name must be in MoA and AoA. Because if we look at the section 11 in bracket 8, registrar may require the MoA or AoA to be amended if name of first secretary is omitted. So that's why it's important to make sure the name of the first secretary must be in the MoA and AoA. Form of AoA must be printed and divided in numbered paragraph. Companies that requiring AoA is company that have a background limited by guarantee, limited both by shares and guarantee, and companies unlimited. Limited by guarantee means the liability of the members is the amount that they has undertaken to contribute to the business property. But for the limited by shares, the liability of member is the amount that they unpaid on the share held by them. So that's a limited by share. And unlimited means the company, the liability of the companies doesn't have a limit. Table A used by companies, a company limited by shares, they're not required to register its AoA. And if we look at the model article, particular in table A were only specimen or sample, and it was open to any company to adopt all or any of them, and even to add some of their own. That means they can refer to the table A, where either they want to adopt all, or maybe they want to take a sum in the table A. If elect not to register AoA, the table A that we discussed just right now, that table A will be the AoA for the company. If the provision in table A not exclude, it will form part of the registered AoA. And this refers to the section 31 in bracket 1, the alteration of article of association. If the company has success binding the AoA, they have a sum effect. If we refer at section 33 in bracket 1, when the AoA has been registered, it constitutes a statutory contract. The binding as if signed and sealed by every members. And that means they have a majority of vote from their all members, and all the members have been signed for binding the document of the article of association. The essential effect, the binding between the company and the member core members, that means they can bind with their each members, or binding between the members intercede. That means they are just between themselves or individual right of them. Statutory contract not divisible and is furthermore incapable of being rectified by the court. Yet, because court does not have jurisdiction to rectify the AoA. This is the example case. If we look at Hickman versus Ken or Romney Marsh Sheep Brothers Association, Article 49, dispute between the association and a member should go to arbitration. Hickman complained about refusal to register his ship and was under threat of being expelled. He started proceeding in the High Court. The court held the contract affects members in their capacity as members. As a member, Hickman was bound to comply with the company procedure for arbitrating disputes and could not resort to court. And that means Hickman need to follow what Ship Brothers Association asks Hickman to do. Like example, Hickman need to register his ship, but he he complained and refused about this. But based on the court, Hickman need to comply. He cannot object. He cannot refuse to register the ship under the Shipbuilders Association. If we look at the Wak Kim Fat versus Leong and Ko Senyam Berhad and Anor, the article provides that the holders of 7 per 10 of the issued capital of the company may at any time serve the company with a requisition to enforce the transfer of any particular share not held by the requisitioners. The second defendant held 2,500 shares out of 300,000 issued shares. He served a requisition to buy out Wong's shares. Wong objected to this, but the court held it is purely a matter of contractual obligation and Wong must be held to the obligation he had undertaken. So that means one cannot avoid this obligation because this is a contractual obligation and he must comply. So that's all for me, and thank you very much.